Welcome back to the Friday Five for December 16th, 2022. My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. Today we're coming to you from snowy Edina, where it's been snowing all week long, but we've still had a chance to get some meetings in with clients and get some estate plans signed before the end of the year. So even though it's been snowing this week and it's been pretty busy, it's also the last Friday Five of 2022. So we'll be off for the next 2 weeks for the holidays. So the next time I hop on for a Friday Five, it'll be 2023. So here's the 5 questions from this week that hopefully you'll find interesting. Maybe we'll answer some of your questions. Number 1, does my executor or personal representative have to post a bond? So if you look at your estate planning documents, which of course you've created, there's probably a provision in your will that says your executor or your personal representative does not have to post a bond to be the executor or personal representative. The reason is if you don't have a will and you're going through the process with your local probate court, depending upon the nature of the assets that need to be transferred, some courts will require your executor or your personal representative to post a bond with the court to protect your estate from any kind of undue influence or something weird happening with your personal representative trying to, let's say, take money from your estate that they're not due. So what we do in our estate planning documents is we usually have a provision that says I'm choosing this person to be that personal representative or executor for my estate, and because I'm choosing them, I also want the court to waive any requirement that they have a bond. That way they can access your funds, they can do the transfers, they can execute on your will and your estate plan without having to go back to the court and post a bond. Number 2 this week, why does the survivorship provision in my will matter? If you're a married couple and you're creating wills, it's very important that you understand the survivorship provision, because a survivorship provision says if both of you die at the same time, which one of you is presumed to have lived longer. Now, when we go back to law school class, what we learn is there's traditional cases where a husband and wife are in a car accident. Both bodies are thrown from the car, the paramedics arrive on the scene, and they've got to determine who dies first. And of course, the husband takes his last breath, and then half second later, the wife takes her last breath. And we have to figure out, did they die at the same time, or did they die, who died first? The reason is, under law, let's say the husband dies first, his estate then gets transferred to the wife, and then the wife's will in this case would be the one that controls how the estate is divided up. Now, many times a husband and wife will have wills that mirror each other, so they have the same provisions, they have children together, and everything is pretty much the same. In those cases, we're not so worried about a survivorship provision. However, if you have a blended family, or if your will is different than your spouse's, the survivorship provision is very important, because if you were to both die in a car accident, we need to determine who dies first, and then the second person who dies would be the one that would control for those assets the two of you had in common. Number 3 this week, am I entitled to see my parents' trust? So if your parents or any other relative set up a trust for you and you're a beneficiary, you may think that you have a right to see all of the documents. You get to see the entire trust, you get to see what's going on. The fact of the matter is, depending upon what state you're in, you may not have that right. You may only be a beneficiary. There may be somebody else set up as a trustee. Their job is to manage the trust, and there can be guidelines for how those trust funds are to be dispersed to you. And depending upon what your parents put into place, or whoever created the trust put into place, they may not actually want you to know what's in the trust and what's being distributed to you. They may not want you to know that, your brother needs more money than you, and so that's why they're getting more money under the trust. Or, for example, that somebody's had a drug problem and they're trying to make sure to protect that particular person from themselves, and so they don't want them to get a bunch of money and be able to spend it on drugs. There can be a variety of reasons why they wouldn't want you to see the provisions. So if your parents or a family member has named you as a beneficiary under a trust, you don't necessarily get to see the entire document. But I can't answer that for you in a video. What you'd need to do is speak to an attorney in your state, have them look at what they know about the trust, and they can tell you whether or not you have a right to get a copy of that trust. Number 4 this week, what happens if I form an LLC, but I never do my corporate documents? This is actually a pretty common question that comes up. These days, a lot of my clients will have set up an LLC and they use an online service. They just mail merge in some information. Those online services mark up your filing fees, by the way. You're usually paying them more than you would if you just filed it yourself, which is really what you're doing with those websites. But then you're cut adrift at that point. Maybe they gave you a form for an operating agreement. Maybe they gave you some corporate minutes, some resolutions, but they're not there to make sure to keep you accountable that those things get signed. So you just have set up your LLC and you haven't done anything with it since then. So what happens is, without that operating agreement, you've chosen a different operating agreement, which is whatever the laws of your state where the LLC is incorporated, whatever they say, that becomes your operating agreement. So if you have a tie, for example, between two owners, the operating agreement would say what happens if there's a tie, but without it, you'll have to look to your local state laws. If somebody wants to sell their interest in the business and you can't come to an agreement on what the amount of that interest is worth, usually your operating agreement has a mechanism to figure that out. If not, you may be stuck with a court proceeding where one party has to file with the court to have it determined what that interest is. So you can still operate as an LLC without signing your agreements, without even creating them, but it creates a lot of problems and a lot of headaches. And it's going to lead into question number 5 this week, which is number 5, will my LLC protect my personal assets if the company is sued? So the basic answer is it should. However, you need to look at the realities of the situation. So if you're running an LLC and you're the only person, the only member of the LLC, and you get into a dispute with a customer and they end up suing you, a very common occurrence that always is upsetting to my clients when they come to me is, why am I personally named in the lawsuit? The LLC is the one that does the work. The reason you're personally named is not that you're necessarily personally liable. It's that the attorney for the other side knows that the LLC may not have any assets and could easily just declare bankruptcy and shut their doors down, and therefore the other party wouldn't collect any money. However, if you, the person, a live human being with personal assets outside the LLC, is part of the lawsuit, they can hope to hold you personally liable, because then things like your house, your car, your bank accounts could be used to satisfy a judgment. Now, the caveat that I give to all of my clients is just because your name is in the caption doesn't mean you're going to stay in the lawsuit. So very often when that happens, the very first motion is going to be moving to dismiss the person as an individual from the lawsuit, that really the case is between the LLC and the customer. It has nothing to do with the individual person, meaning you, the owner. This is why we go back to number 4 as far as creating operating agreements, because you want to be able to go to the court and say, listen, the LLC is more than just me. I didn't just create this to avoid liability. The fact is, it's an ongoing business. Here's my operating agreement, my corporate minutes, my annual reporting you can see with the state. We want to show these documents to show that it's a legitimate business. I work with an accountant. I keep my P&L statements. All these things can come up, and they can show that you have a legitimate business, as opposed to just the name of an LLC that was formed online and there's no other information that's even an active business. In that case, it looks like it may be a way for you just to try to protect yourself, and what the plaintiff is trying to do is what's called pierce the corporate veil, and that is get in through that LLC and get to your personal assets. So those are our 5 questions for this snowy December week here in Minnesota. If you'd like to submit a question for future videos, there'll be a link in the description below. And please have a wonderful weekend, an amazing holiday season, and I will see you again in 2023.